Dude, we should get tacos after this.
Like now? Do we have to wait?
Let's finish the episode.
Okay. Yeah, I'm down.
Welcome back to Lawish. We're back. And let me ask you this question, Jeff. Have you ever hit a woman with your belt? Not just hit a woman. Hit a woman with your belt. Recorded yourself doing that. But it was consensual. You had to tell the truth.
This is being no.
Okay.
Yeah.
Comment down below if you believe Jeff. If you believe he's never done this. Anyways, today we are talking about the hot gossip.
Andrew Tate.
So YouTube is the last of many social media platforms to ban Andrew Tate from their platforms. So first I think it was Twitter many times.
Yeah, 3 months ago or three times.
3 times, and I think the last one was it was like plenty of times, and then Facebook and Instagram, so Meta owning both of those, banned him on their platforms. Yeah. On the 2 platforms, and then YouTube now did that. Now there's a little bit of a, and this is neither here nor there, but there's a little bit of an argument that TikTok also did that. Mm-hmm. There's one article that says that he didn't have an official TikTok account, even though his videos were taken from YouTube and then shared on TikTok. But then there's another one. I think TikTok told NPR we ban his account. Okay. So who knows? Yeah. The main point being that Andrew Tate has been banned from almost every other popular social media platform. Now,
he got canceled.
He essentially got canceled.
He got canceled big.
I mean, we don't know if it's still on Truth Social. We don't know if it's on Gap or some of the other like the more conservative platforms. But at least YouTube, Facebook, Instagram, TikTok, Twitter, he's gone. Yeah. And if you're not familiar with Andrew Tate, well, you're not going to be able to be familiar with him anymore because his videos are being taken down. And his content is being taken down. I think your best shot is probably like going on TikTok and trying to find some of that, because even if he did not have an account, you know, some of these figures are saying that his videos with the hashtag Andrew Tate were being watched in like the billions, like double digits billions, like 11 billion, 13 billion times they were viewed. And that is a ton of views.
He was apparently more searched than Kim Kardashian and Trump combined.
And that is saying something.
Combined, yeah.
Yeah.
That's insane.
Well, anyways, the reason we decided to talk about Andrew Tate today is not because of his views, whatever he posted. I did not know who Andrew Tate was until like maybe 2 days ago. Yeah. And then you said that you were like randomly kind of like just scrolled and then like, oh.
Yeah, I saw a handful of his stuff through other like videos basically that would either react to his videos or it would just pop up when I was scrolling through Instagram. You know, he was talking to somebody or interviewing somebody.
Yeah, so it's not necessarily someone that we were really familiar with, his work or his content. But the reason we decided to make this episode was when we found this article about YouTube being the latest of the platforms that banned Andrew Tate. There were a lot of comments and reactions about, oh my God, that's a violation of the First Amendment and whatnot. And once we hear those magic words, the lawyer in you is like, all right, let's set the record straight. Yeah. So today we're talking about the First Amendment. Well, not actually. Let me backtrack. We're talking about the First Amendment in the context of this ban. Yeah. Because the First Amendment, as you may know, is just huge. It encompasses a lot of very, very fundamental core rights of U.S. citizens. But in this case, we're just talking about the First Amendment, freedom of speech, in the context of social media platforms.
Yeah, because we could have like a 24-hour long episode just discussing the law around, even freedom of speech. Yeah. Right, in general.
Just the concept in general. So not even in the context of this, but the concept in general.
There's a ton of case law that's been, obviously, really since our founding, been challenged through the Supreme Court. And through that, we got a bunch of different tests and standards. And we're not going to go over all of that, obviously, in this episode, nor do you all want to hear about that. This is going to be a very focused Honestly, it is, and it's confusing because
This is
you have a
yeah.
test that changes 8 different times.
Yeah.
just
And
for
it
the
kind of
same
just,
thing.
for the most part, you
Yeah.
know, it just kind of goes over your head, not because you don't have the intellectual capacity to understand it, but it's just because it's all over the place.
It is.
It's like, so in
It
the end,
is.
you're just like, there's like, well, so then what is the rule?
Yes.
Who knows?
Exactly. Yeah. So, but this, very focused, very narrow kind of analysis based on specifically social media in the First Amendment, and to whatever extent the First Amendment or doesn't apply, more
Right.
so. But to the extent that the First Amendment applies to social media platforms.
Great. So let's dive right in. And I think the easiest way to break this down again in this very narrow context is kind of take it from the general to the specific. Generally, the First Amendment freedom of speech applies to the government,
Yeah.
not to private entities, actions by the government. But Jeff, why don't you read the text of the amendment?
Yes, the First Amendment itself says, quote, Congress, emphasis on Congress, shall make no laws respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or the right of the people peaceably to assemble and to petition the government for a redress of grievances. And the Congress in this situation, it was later kind of really just determined to be the government. Okay, so the
Right.
government
The
itself,
state.
yes,
And
the
that could be,
state.
and not as in one of the different 50 states, but the state as in the government.
Yeah, exactly. And so you'll hear, and that's kind of confusing for a lot of people. I get that too. But even like political science, a lot of times you'll hear like, they'll refer to states and it's countries they're referring to. Right. But we're like, well, what do you mean?
What they call state actors.
Yes.
And that just means a government. It could be federal. It doesn't need to be an actor from a given state.
Yeah. So the First Amendment specifically applies to Congress, which is the state, the government. Okay, the federal government, or sometimes local or state governments, but the government itself.
Right.
And why does that matter, Jabron?
Bruh, I wasn't ready. Well, it matters because in this case, we're talking about social media platforms that are presented to the public by private companies.
Yes.
And now there's been a myriad of discussion about, Twitter or Facebook or Instagram. They've grown so much that people argue they are now, public square. And again, not to kind of dive too deep into the First Amendment, but once we go into the actions by a state actor or by the government, you have different types of venues, right? And a public forum would be one of those venues that is traditionally open to the public for them to come and go. And in that particular venue, in that particular forum, then you can say whatever you want, with minor exceptions.
Yeah, within reason.
So then, yeah, exactly, within reason. But we're not going to get into that again because it's not relevant to this particular case.
Yeah.
The reason I mentioned the government public forum is because there have been arguments about Twitter or Facebook or Instagram being de facto public forums, a public square where people go in and share their opinions, meaning at that point in time, these private companies should not have the right to censor or ban someone from that forum without proper scrutiny because they're violating the First Amendment.
Yeah, so and within that, you couldn't, obviously, if it was considered a public forum, you couldn't say, which is what's happening in this case, I think, it is viewpoint discrimination. You can't say, hey, we don't like what you're saying, we don't agree with what you're saying, therefore it's problematic because we don't agree for it, we think it's going to be, corrupt our children, whatever the case may be. That would be a violation of the First Amendment if this were, in fact, a public forum.
Right. And that is really the case here. Like Andrew Tate was kicked out because he was, quote unquote, deemed a threat to young men. And his content was considered in violation of the guidelines of a lot of these websites, their terms of use.
Yeah.
And that's kind of what brings this whole thing around about people, oh my God, they're violating his freedom of speech because they're banning him or they're not allowing him to have an account.
Yeah. Yeah. You saw that a lot. I mean, I think over the years, specifically since kind of Trump started running for president, but even before then, but there was a lot of, on both sides, things that, people didn't agree with. And then people were like, well, it's freedom of speech. This is America, whatever. And again, it ultimately, as we just stated, comes down to the classification of whether or not it's a public forum or not. If it's private, it changes the entire analysis and whether or not the First Amendment actually applies. There's exceptions, right?
There are, absolutely, there are. But one thing that we should make clear right now, so you can go and tell your friends, or if you're participating in a conversation about First Amendment, which it seems like they happen a lot more often now, more than before. This is a private company. And private companies, when you sign up for an account on Facebook, on Instagram, whatever, those terms of use that you don't read,
nobody reads, quite frankly. But
they draft them, and I didn't read them either.
No.
But they draft them, and they're saying you are agreeing to abide by these terms of use and terms of access, essentially. And if you don't, we have the right to just kick you out.
Yeah,
that is what Twitter was using, and Facebook and Instagram, to say we have the right to kick you out because you're violating our terms of use. Yeah,
it's no different than if you went to your local grocery store or gas station, started yelling stuff that for whatever reason the manager thought was causing some sort of uproar or customers to get kind of bothered by whatever you're saying. They're going to kick you out. It's the same thing because this is a private company. This is a private organization, and they have the same rights as those do. You wouldn't, on the other end be like, oh, okay, like if you say you had your own business, right? And some guy comes in there saying some crazy stuff, or at least in your point, that's crazy, or it's upsetting your customers. Are you going to want the government to make you keep that person in there because, it's freedom of speech? No, hell no. I don't think anybody would think that. But it's hard to see because, you associate social media kind of as being the same thing as you went out on the street. But it's not, right? It is a private company. It's run by a private company. It's not the government social media site.
It is, for all intents and purposes, a delineated property because you're accessing their servers. So it's as if someone walked into your property and you have, to your point, the right of admission.
Yeah.
I have the right, I reserve the right to refuse service to whomever I want to refuse service to for whatever reason I want to because it's private property.
Yeah.
And that is
with
it.
With a few exceptions, right. Obviously, but
yeah. You can just be like they're racist and saying, oh, why you can come in because you're a woman.
Yeah.
Well, that's not
how it
works. Yeah. But aside from that, you have almost unfettered right to say who comes into your house, who comes into your business.
It's like the no shoes, no shirt thing, right?
Right.
And then that's even more, I think, in a lot of people's viewpoint, you're not even doing anything at the point other than not wearing shoes or shirt. But it's like, if you're okay with kicking people out for that, and government, or private actors can do that, they should be able to if you're saying stuff they find offensive or it's going to offend their customers. So it's no different, and I know people view it differently because they don't really make that analogy, but it is a private company.
Yeah.
And so the First Amendment does not apply unless there's very few circumstances that it does apply, where private companies will be viewed as being state actors.
One of those is, and we saw this in law school, is when the private actor is undertaking responsibilities or actions that have been traditionally exclusively under the purview of the government. So we saw a case in law school, and I can't remember the name, but I'll put it on the screen right now. And in that case is where a private company was essentially setting a town, right? And by virtue of doing that, they were, making sure that everything was in place, whether that be utilities and street lighting and all these different functions that normally a government would undertake, they were taking them. So in that case, they couldn't keep random people from the town because that then became a public forum.
Yes.
Right? Because now you are acting as the government, and now that you're essentially within the umbrella of a state actor, there's certain things you can't do because of the First Amendment.
Yeah, and so for that specific one to apply in this situation, it would have to be like the government always had a social media site, right?
Right.
Or it was like the government always ran social media, and then all of a sudden you're doing it for them or something.
We're essentially delegating and having someone else do it. They're still doing it for you, so they're your designees.
Yes.
And they need to abide by the same rules. But in this case, that's not the case.
Yeah, it's not. Yeah, so all three of these exceptions are under what's called the state action doctrine. And basically it's saying the reason the private company, the First Amendment does apply to them, to these private organizations in these very limited situations is because they are acting as the government. They're acting as the state Therefore, they shouldn't be able to just say, hey, we're private companies, we can get around that, because, what they're doing, is basically applicable to what the government would be doing. So it doesn't make sense to allow them to kind of get around the First Amendment in those situations. And then the other two, the second and third kind of are related. There's the Entwinement exception and the Entanglement exception. They're basically kind of both getting at, if you have a private company that there is so much essentially government involvement with that company that it's hard to kind of pull the two apart,
right,
and disperse the two and say, okay, this part is private, this part is government. They're just going to view it all as the government, essentially.
Yeah.
Just to kind of like err on the side of caution, and in that situation, the First Amendment would also apply. None of these three exceptions apply to social media platforms.
That's right. Because they're not performing any amalgamation of government-like and private-like functions that then blur that line between a private entity and a governmental entity.
And we saw one situation started in 2016, or at least the situation itself started in 2016, where the government kind of did come to a conclusion that, at least in that limited circumstance, one specific individual's account was determined to be essentially the government.
Guess who?
Any guesses?
Any guesses?
It's not Hillary Clinton.
Oh, no, that was going to be my guess.
Damn it. It was Hunter Biden. No.
Jeez.
It was Trump. Not surprisingly, all right?
Yep.
Since he tweeted, and the reason they came to that conclusion mainly was because that was his main source of communication. Trump tweeted everything. That was his main, even more than doing press conferences or putting out statements, it was him sitting there tweeting. And so that became basically his way of communicating with the society. And so in that situation, he is very obviously a state actor. He is the president. He's the government. He is the state. And he is communicating. So his account specifically, there was not allowed to be, any sort of funneling based on viewpoints or any sort of discrimination based on what somebody said because of, their ideology or their politics or whatever the situation would be. First Amendment applied specifically to his account, not to social media in general, but just because of who he was.
And this is a very important distinction that we have to make, though. The result was that Donald Trump's account could not discriminate against other people, meaning block people based on their viewpoints, because his tweeting was the action of the government.
Yeah.
But that did not mean that Twitter could not ban him from the property.
Exactly.
So it's when it gets into a little bit of a meta situation, because, like, to your point, him tweeting was the government speaking.
Yeah.
So you couldn't then just have someone go in and respond to you on Twitter and be like, nope, blocked.
Yeah.
No, because that is you speaking, meaning you cannot, as the government, violate the First Amendment by silencing someone. But Twitter, in the Twitter sphere, is still that private property.
Yes.
Which is why they could still ban him from Twitter if they violated the terms of use, but he could not block people from responding to him.
It's a very interesting, because it is, because they're a private company, and it's like they're not required or obligated to let the president have accounts just because he's president. He agreed to the same terms of use as everybody else. So, it's like they can block him, they can kick him just the same as anybody else. But like you said, if he's going to be on there speaking, it changes who he can effectively block or silence or limit because of that. Again, viewpoint discrimination is not allowed. And since he is a state actor, he is obviously, I think, the highest state actor, arguably, obviously, is the president.
Right.
Yeah. So it is. It's interesting. It's an interesting dynamic. It's like he doesn't have a right to have an account through Twitter or Facebook or anywhere else.
But if he has one,
he's going to,
and he's only using it, he cannot block other people from it because it's a state actor action.
It was a very unique situation, but generally, as anybody else, and I guess you would run into that maybe similar with potentially some Congress people, like if you had a congressman or something. I don't know, who knows, but you might run into the same kind of situation. But it would ultimately be the same outcome. They could kick them at any time too, and they just couldn't silence people based on viewpoints.
Yeah,
but it's. At the end of the day, the whole freedom of speech thing, it does not apply to social media. It does not apply when you're on Facebook. If somebody says something, you say something that Facebook doesn't agree with, and they ban you, and you get upset, and you're like, my freedom of speech. It's
not gonna fly.
Yeah.
And I mean, I shamelessly kind of pulled out my notes while you were talking earlier.
Oh, all right, little cheat sheet. Okay.
I wanted to, bruh, shut up, because I wanted to make 2 points. So,
good points, at
well,
least?
one, they're very great,
Okay, the
the greatest points. When the peak of the discussions of whether Twitter and Facebook could ban, representatives or whatnot based on their viewpoints, there was a discussion of repealing 230. Well, that is Section 230 of the
CDA.
Communications Decency Act, is the CDA. There was a case in 2021 of a channel that YouTube put it was not a ban, but it was like a restriction. And if you're familiar with YouTube, when you upload a video, you mark whether the video is meant for children or not. If you say no, and depending on certain topics or hashtags or even the content of your video, YouTube can decide, okay, this is specifically for people of 18 and above or whatnot. Well, YouTube placed these restrictions where if you are a parent and you have the parental restrictions on your phone and you're giving to your child, this video from this channel would not come up. It would be essentially restricted. It would just not be shown. Why? Because you have those filters. Well, this channel was saying they're violating our freedom of speech. They said that YouTube took on the traditional government function of providing a forum for free speech, so it could qualify as a state actor required to be viewpoint neutral. And viewpoint neutral means when you have this forum, you cannot essentially cancel people or block them or silence them based on their viewpoints. The judge disagreed and said, YouTube's hosting a speech on a private platform is not a traditional and exclusive government function. Is what you and I were talking about earlier today, where we said the fact that you have these platforms right here, it doesn't mean that the government has been doing it for forever. It's not.
Exactly.
They're doing their own thing. It's private. It's new. They get to decide their own rules. The plaintiffs, in this case the channel, came back and said, well, what about 230? The mere existence of Section 230 of the CDA implies that the government is compelling entities such as YouTube and these platforms to be state actors. It's a weird argument.
Yeah.
And the judge was like,
Was that
well, no, the CDA was, quote, intended to maintain the robust nature of the internet communication and accordingly to keep the government interference in the medium to a minimum, end quote. So the judge was like, no, it's completely the opposite.
Yeah.
The existence of Section 230 is not to compel you to do governmental functions. Is to keep the government outside of your business.
Yeah.
Because 230 of the CDA, one of the biggest things is that these private entities are not responsible for the content that other people put on their platforms.
Yeah.
And that makes sense.
You can't be like sued civilly because somebody said something that you can't control. I mean,
Yeah. So if you and I are members of Facebook and I said, you're a kid, I'm probably going to censor that.
The fakest of news.
But if I say that, you can't sue Facebook because I said that to you.
Yeah.
Right? This is all between me and you.
I mean, I could try, but
You could try because in this country we could just sue whoever we want if you want to waste some money.
Sean Hannity, if you're listening, I need an attorney. So,
Bro, his focus is on constitutional matters, so maybe you'll be able to help you
yeah,
here.
First Amendment. He's very familiar with that.
Anyway, so that just it was just a point to our earlier discussion about how having these forums for people to communicate does not make these platforms a public forum.
Yeah. No, I think it's a good point. I think it's an interesting argument. I'll say that. And I get why people, if you don't go to law school, you don't realize. I mean, it is even for people in law school. It's confusing as heck. You're going through.
Not for me though.
The constitutional law. There's probably like 30 cases in the First Amendment, and like half of those have their own tests. And then you get to the end, and they're like, "Oh, we're throwing all these out."
Which one do I use? And like,
I think
none of
this
them.
is like lemon. We're doing lemon now. No, but yeah, it's a mess. But at the end of the day, if it is a private organization, a private company, the First Amendment doesn't apply. Yeah. And that's in a story. Doesn't matter if it's a store, privately owned store, if it's a social media platform, whatever the case may be, you do not have freedom of speech to say whatever you want. You can say whatever you want, but they can kick you out or ban you or do whatever they think fit based on that. And to be clear, I think in general, cancel culture is a problem, but that's not what we're talking about. We're talking about the law.
And we could talk about that in a different episode, but I think to your point, there's a difference between a company banning a user for a violation of the company's terms of use.
Yeah.
And someone or a lot of people asking company to ban the user because they said something they don't like.
Yeah, exactly.
Those are two different things. The latter is obviously cancel culture.
Yeah.
The former is I just decide who the fuck accesses my platform, and if I don't like it, you're screwed.
Yeah.
Go do it somewhere else. Because think about this. The First Amendment preserves your right to be an asshole.
Yeah.
But it doesn't mean you can be an asshole whatever you want. Go be an asshole at your house.
Yeah.
The First Amendment. Protecting your right to be an asshole in your house. Since 1971.
But you don't have a constitutional right to be an asshole
everywhere
on Twitter.
Yeah.
If they don't like it, you're out.
Yeah. Yeah. And you might not think you're an asshole, but at the end of the day, it's like that is their private company.
Yeah.
Their property in a way. And it's like you can't just go in there and do whatever the heck you want and expect that to be okay. If they don't like that for whatever reason, sorry.
Yeah, and I use the asshole as an example, but
but I get what you're saying.
If you wanted to talk about nonsense about ponies,
Yeah.
and for some reason the terms of use said prohibited
Yeah.
speeches, ponies, it'd be the same
But
thing.
you see it all the time. You'll see like even groups within, Facebook. It'll be, and that's like a whole different thing. But let's say like, our guidelines like no promotion, right? You can get kicked out for that. Are you going to sue them? It's not going to go anywhere. Like at the end of the day, you don't have a right to be on any of these platforms because they are private companies. You don't have a right to do anything that's private, right?
At least not that is found in the Constitution.
Yeah, I mean, exactly. So it's weird, it's confusing, but at the end of the day, if somebody gets kicked off of Facebook, it is what it is.
Yeah.
The government is not involved. The First Amendment does not apply.
Now, let's make this a little bit more confusing, and this is how we're going to leave the video. There has been a new wrench thrown at the whole machine. And that is the question of common carriers. Mm-hmm. And common carriers originally was for service providers whose services were almost like essential, like they only were the only ones that provided the service, like transportation.
Yeah.
But then it kind of bled into like phone providers and cable providers. And there is right now a case at the Supreme Court, this article written by Alison Frankel, that temporarily blocked a Texas law where the Texas Attorney General was saying, well, Twitter is a common carrier, meaning to some extent they are providing a common carrier function, so they cannot block people or ban people based on their viewpoints. And commonly, the definition of a common carrier is one that dominates the market for an essential public service. Mm. Now, obviously, the Texas Attorney General was saying Twitter is somehow providing an essential public service. Whether it's essential is debatable.
Yeah, I think a lot of people
it's definitely not public.
Social media does more harm.
And if it's a service, well, it depends on how you use Twitter, right? Because sometimes you just waste time.
That's what I'm saying.
I would doubt that's a service.
There's a lot of people that, like scientists, psychologists, that'll tell you that social media does more harm than good. So I don't know how you're saying it's essential.
Exactly.
We've lived without it for the longest time.
So the reason why it's kind of like up in the air, it's kind of important, is because the 11th Circuit said no. They are not providing that. No, not in my circuit. So this happened in Florida, and the 11th Circuit said that Twitter and Facebook have not become such important pipelines of information that they are in effect public utilities. Like that's like you can live without Facebook and Twitter.
Yeah.
You cannot live without water or electricity, or gas. Right?
You might not think you can, but you absolutely can.
Yeah. It may seem weird to kind of quit cold turkey, But
or even
you
your
can.
phone, right? I mean, you
Right.
need to be able to call for
Even emergency
now, whatever
services,
the
or
lives are. You don't need Facebook.
because now you don't have like landlines,
Yes.
right? So you need a cell phone, but not Twitter or Facebook. The Delaware County Court of Common Pleas did entertain an Ohio suit
Classic
that
Ohio.
also called social media a common carrier. I think it was Google. Yeah. In this case, they're not saying, Google is a common carrier. They were saying that the state at least made a reasonable complaint, enough to survive just summary judgment.
Yeah, I get
and that
that.
really is it. So that just means it's not going to be tossed out right off the bat. You get to essentially say your piece. So the reason why I bring this up is because if we get into common carrier territory, which I doubt it again, I don't think it's an essential public service. I don't think it's a public utility that you need to survive.
Yeah.
So I doubt it's going to go there. But the fact that the Delaware court kind of entertained the thought kind of gives a little bit of kindling to the argument. Well, maybe they are providing some sort of like governmental function that will then shift the tide somewhere else.
I mean, it's we've certainly heard it's not a terrible argument. I agree. I don't agree. I agree with you. I think we could absolutely do without social media. But yeah, I mean, why not? Why not try it? I guess if that's how you feel. It's not the worst argument. So that's interesting.
Well, the only other thing that I wanted to mention from Frankel's article was that they mentioned that the common carrier issue, meaning this question that we just talked about, is before the U.S. Supreme Court entangled with other topics or other issues that deal with the First Amendment.
Yeah.
And where they're going to determine, whether social media platforms can engage in content moderation based on viewpoints. And so it's going to be interesting to see how that pans out.
Yeah, I think it's also it's interesting. It's also kind of terrifying if you think of the alternative, because a lot of what got banned through that was groups associating with Al Qaeda and ISIS and other terrorist organizations. Right. And I mean, granted, you could still try to, through hate speech and other avenues that can be regulated, but they could still recruit on social media because of their general beliefs, I would imagine. If this was designated, if they were found to be common carrier and the court were to go along with this, that's a problem, right? So I don't know, especially because we know how much social media literally touches everybody.
Yeah.
And that's how the number one really kind of thing that really promotes homegrown terrorism, gets people to radicalize who are sitting in their house doing nothing. That's terrifying. So there's serious implications if the court were to find that outside of, just, let's not cancel people or people got a different viewpoint. It's like, do we really want that? I don't know.
Well, so the summary is kind of, piggybacking on what Jeff was saying. When you participate in these platforms, you are subjecting yourself to the terms of service of the platform, the terms of use. And if they ban you, it's because they have the right to do it. They're not state actors. At least so far, they haven't been found to provide an essential, traditionally governmental function. And up until now, they haven't been found to be common carriers providing this essential public service. So let's take the discussion somewhere else, because the First Amendment, that's not where you're going to find a justification for getting someone back on the platform.
Yeah. I mean, you could have you could maybe have the argument that you think there needs to be more conservative leaning social media organizations, and that's, certainly an argument, or you're right to do that. But yeah, it's like the First Amendment just doesn't apply. Yeah. End of story.
and in this case, I think, because you could have the most left leaning person, and if you're just saying stuff that violates the terms of use, you're out too. Yeah. So it's not censoring of conservative viewpoints. Is whatever your viewpoint is violating a particular provision of the terms of use. So what is it? And just don't do it.
And when you had some like radical people in like the far left that were like saying people need to be hung and stuff, that were conservatives because they didn't agree with whatever, and they same thing happened to them. They got kicked off, and they should. At the end of the day, they have a right to do what they want. And if that means they don't want a certain viewpoint or a certain side saying some things on it, well, find a different platform, unfortunately. I mean, that is, and I think all of us would want that if it was your company, it was your business. you would want to be able to monitor and regulate who says what in your store, on your forum, your website, whatever the case may be. And so, like you said, you might not be okay with it. There might be other avenues to bring that up and kind of, have that discussion. But the government and the First Amendment, the Constitution, does not apply to private companies, is at least as far as the First Amendment goes, barring a few exceptions.
Yeah, which we might get into at a later time.
Yeah. Well, that was a quick, and it might not have seemed quick, but certainly is as far as how far we could have dug into this.
Definitely brief. As brief as it could be. It's kind of like the tip of the iceberg,
Yeah. There's a tunnel we could have went through that would have kept us here a lot longer. Unfortunately, the First Amendment law, like I said before, goes just on and on and on and on. There's a ton of cases. So
Agreed.
We try to summarize it in the best way we could, at least as far as it relates to private companies and social media. Yeah, Jabron, do you have anything else to say? Or
No, not really. Just remind our listeners, our viewers, to let us know what you think. Hopefully you found this helpful, at least to understand a little bit of the intricacies of the First Amendment. So please let us know. Your feedback is always appreciated.
Yeah, and on that, I would be interested to see, at least given like kind of what we've laid out in here, do you think the First Amendment should apply to private companies and to the full spectrum and, the implications that would have, or do you agree that it should only apply to the government? So I'd be interested in hearing what everybody has to say. This was Lawish.